Greetings to all our viewers. Today, as usual, we are going through the cases and questions from our clients. Over the past months, we've gathered the most interesting and popular questions related to the startup visa in Canada and its requirements. We will be discussing those with our most trusted licensed immigration advisor, Oleg Schindler. Hi, Oleg. How are you today?
Thank you, Anna. Thanks. Happy to be with you again. And greetings to all our viewers from Ottawa, the capital of Canada.
Let's dive in. If I committed a minor administrative offense in my home country, which doesn't carry serious consequences, but in Canada, that the same offense could be considered more serious, even criminal. What's the best course of action here?
This topic is very, very important and requires thorough analysis in every single case. Let's start from the basics. So first and foremost, every time while we start consulting the client, we ask them to provide us the full background, the whole story, so we know what we are dealing with. Transparency here is very important because it is in our best interest to be fully aware of the story of the client, so we know how to help them to interpret it in the best way. Canadian government has a very interested approach towards offenses committed abroad. In regular cases, the government simply checks what would be the punishment for this offense should it have been committed inside Canada. Depending on this, they apply different approaches, and depending on the seriousness of this crime, the volume of such offenses, there might be slightly different approaches in what we do. In some cases, when the offense happened longer than 10 years ago, and this offense is regarded as like a minor offense in Canada, we are automatically applying the notion that the applicant is already deemed rehabilitated. At the same time, some types of offenses may have a bigger impact. For example, I always advise all our clients and speak a lot about driving under influence, DUI. In Canada, it's a very, very serious crime. I know that in some countries, like driving and drinking, it's not that serious in Canada, but like here in Canada, it's a very, very serious offense. And like I strongly advise, don't drive and drink. Overall, if the client still is not deemed rehabilitated, in this case, we have the procedure which is called application for rehabilitation. So we usually start this process before we submit the application for PR, and we want it to be completed before the PR application. In this case, when the client is rehabilitated, we include the decision about rehabilitation into PR application. And in this case, it doesn't pose any risk to the application. And obviously, in some extreme cases, when the offense is serious, in such cases, we will simply advise to wait more years or to postpone the application, or even to think about other countries to immigrate to, because we in Canada here, we want good immigrants. Canada is tolerant, but it comes with a price. We want to have this safety and security that we all enjoy in Canada. That's why we are very, very careful in who we allow to come to Canada. Misrepresentation, it's a very, very serious issue in our immigration. If for some reason client hides some type of this information from the government, this may result not only in refusal of the application, but even in ban for 5 years to enter Canada. So that's why we must be transparent all the time, and we must always provide all the information. And again, depending on the circumstances, we will always advise on the best course of action regarding the security clearance.
If I previously lived in another country, for example, for 6 years, but no longer reside there, due to safety reasons, I cannot obtain a clearance certificate from that country. What are my next steps?
Canadian government would like to see the criminal clearance certificates from all countries of citizenship and all countries of residence where the applicant have lived for longer than 6 months in a row. However, we all understand that life is complicated. Sometimes some countries have very tough international relationships with other countries, and sometimes it's literally not possible to obtain a specific document. In such cases, our goal is to demonstrate our best efforts to try to get this document. So if client is not able to communicate with the government of specific country, and get the police document, we need to demonstrate that we at least submitted requests and got declined them, or to demonstrate that it is not possible for us to do that. For example, if the country A has severe ties with country B and it is dangerous for the citizens of country B to come to country A, we will literally provide a detailed explanation to Canadian government that, look, there is a tough international relations between those countries, and if our clients decide to go to this specific country, he may be at risk of imprisonment, he may be at risk of physical danger, etc. So in such cases, we need to demonstrate that we did our best to obtain such a document, but for the reasons beyond our control, it is not possible.
Another legal aspect, I know that people don't necessarily have to be married, and it's enough to sign a document confirming the relationship to immigrate to Canada together. What are these documents, and what exactly is being referred to in this case?
Every time when we have common law partners, we try to collect as much documents as possible that will confirm all aspects of common law partnership according to the definition by Immigration and Refugee Protection Regulations. So, two adults in romantic relationships who cohabitate together for at least 12 months and have common household are regarded as common law partners. This means that in such cases, we will do the following. So if they rent and live together, we will ask to provide us a lease agreement which outlines both names of the couple in the lease agreement. If they own a property, we will ask to demonstrate that they co-own this property or that they cohabitate together in the same property. This could be in the form of, bank statements on the same address. This could be joint bank statements. This could be various utility bills, phone bills, etc. So, all possible documents that demonstrate the cohabitation. Next category of proofs about common law relationship, it's photos. We always recommend our clients pick up the best photo of you together in the last 12 months, one photo per month, or one photo per every 2 months. The idea is to demonstrate that public is aware that you are a couple, that your relatives, that your friends, they all know that you're a couple, and we provide photo collection to the officer, which demonstrates you in different situations. On vacation, on a date, in a restaurant, on the birthday of parents or friends, etc., etc. So we literally provide a collection of photos with dates, places, and who is on the photos. Next aspect of common law relationship that we use in the application is snapshot of the communication. So we live in the modern day technology world, and people are communicated through WhatsApp, through Telegrams, through Viber, through Messenger, whatsoever. We literally ask our clients to pick snapshots of their daily communication that will prove that there is a romantic relationship, sending kisses, sending sweet words. Second aspect, we ask clients to provide screenshots of their communication which demonstrate that they cohabitate and have a common household. For example, husband is returning home from work and wife hands him a message. Sweetheart, I was in the super today, but I forgot to buy a milk. Can you please bring milk at home? Obviously, on top of that, we usually demonstrate various financial relationship between them. A couple rents together and one is paying to the landlord. The second is transferring half of the amount to their spouse. We also include letters from family, from friends. It's not really complicated to prove a genuine relationship. So as long as people are really in a romantic relationship, live together and have common household, it's easy to prove it. It's just a collection of documents and additional work for us.
I've come across information that IRCC may request so-called progress report on my startup. Can you please clarify what it entails and how often it needs to be proved?
Due to long waiting times right now, IRCC wants to verify that at any moment the business applicant is still progressing and is still developing their project. So from time to time, they submit those requests asking to provide a progress report. Basically, what they want to see is that you did not abandon your idea and that you keep developing it. So they want to see that you're doing a market research. They want to see that you meet with potential stakeholders. They want to see that you approach potential partners or potential clients, that you do something related to your business. Usually we submit such report in cooperation with our business consultants. Generally, like we simply, depending on the nature of the project and the specific wording in the request of the government, we simply answer it and we provide exactly what the government is asking for. But again, like I want to emphasize, the idea here is to demonstrate that the client is still actively involved in developing his or her startup.
Oleg, thank you very much for your valuable insights and for making time for us today. I'm confident that it will help our audience with their aspirations to move to Canada.
Great. Thank you for having me today. And as always, I'm very happy to provide your clients with knowledge they need to come to Canada.
Thanks everyone for watching this video. We'll see you soon.